The defense strategy unraveled in a single, quiet moment as the judge posed just one pointed question in an otherwise hushed courtroom. The room was filled to capacity. Cameras stayed locked on the scene, journalists sat ready with their notes, and staff members visibly tense. Most people anticipated a standard proceeding, legal filings presented, routine objections noted, procedures followed as usual. Donald Trump appeared assured, relying on the groundwork laid by his legal team, settled comfortably as he anticipated the familiar arguments from his attorneys. Then came the judge's move, understated yet powerful. He directed one measured, straightforward question to Trump's primary lawyer. No raised tone, no theatrical flourish, simply a clear and targeted inquiry that cut straight to the core of the defense position. Silence fell over the courtroom. Reporters, support staff, and onlookers all paused, attention fixed. That one question sliced through the defense's carefully built case with precision, like a sharp instrument exposing what had been hidden. Trump's attorney paused, visibly caught off guard, searching for the right words to respond. In that short delay, tension built rapidly. This was no loud confrontation or headline-grabbing display. It was a precise, authoritative strike delivered from the bench. Others in the room, fellow attorneys, observers, potential witnesses, grasped the meaning right away. The defense now stood exposed, weakened, and under serious strain. Assurance among the team began to waver. Supporters started questioning their stance. From that point forward, every statement carried added significance, shadowed by the earlier uncertainty. What made this exchange so effective was its restraint. The judge required no drama. A single, well-crafted question dismantled weeks and months of planning, shifting the defense into a position where they could only respond rather than lead. As events unfolded afterward, the impact spread well beyond that one session, affecting how witnesses approached their roles, how evidence was managed, and even how Trump presented himself publicly. When the lawyer hesitated, the atmosphere in the courtroom changed from quiet tension to clear vulnerability. That question went deeper than a minor detail. It targeted the foundation of the entire defense story. For a long time, Trump's lawyers had built their approach around carefully drafted filings, chosen pieces of evidence, and assertions of broad protections tied to executive authority. Suddenly, all those elements rested on an unsteady reply. The response came quickly but showed clear signs of trouble, pauses, uneven wording, and inconsistencies that made their way into the official record. Prosecutors spotted the weakness immediately. They stayed composed, no need for raised voices or showmanship. The record alone captured the doubt. Every member of the press in attendance felt the shift. A prominent legal effort was coming apart before their eyes. Witnesses, those in the room and others following from afar, had to rethink their own involvement. Close associates and former staff members saw that the shield they counted on might no longer hold. This set off a broader chain of reactions. A single, uncertain reply opened the door for more cooperation from witnesses who had held back before. Any small inconsistency or slip now gave prosecutors stronger ground to press forward. Assurance eroded. Loyalty among supporters came into question. In the legal process, that kind of uncertainty leads to concrete outcomes: stalled filings, less effective challenges on appeal, and greater risk during questioning. The shift reached the public as well. News organizations, online discussions, and political analysts quickly highlighted the lawyer's difficulty, presenting it as a sign of disarray in Trump's legal approach. The quiet in the courtroom became a powerful indicator nationwide that the defense faced heavy strain. This shows how one calmly delivered question can spark a series of connected effects, building internal pressure, creating legal openings, prompting witnesses to reevaluate, and drawing wider attention, all working together to weaken the overall strategy. Behind the defense table, the uncertain response sparked immediate disorder. Attorneys murmured among themselves, moved documents around, and spoke quietly to Trump's staff. Arguments built over time on protections, on narrative control, suddenly seemed far less solid. Prosecutors sensed the opening and began adjusting their plans, aware that a pressured defense often leads to further errors, conflicting statements, or overlooked details. Preparation for witnesses intensified. Staff members who could be called to testify recognized that the defense's reliability was fading, allowing prosecutors to highlight even small differences in accounts. Trump himself showed clear signs of the impact in the room. He understood that this one calm question had laid bare weaknesses his team had depended on for months. His usual confidence dipped, and those around him worked to maintain a steady appearance while privately assessing the fallout. Picture a tense game of strategy where one side spots a small signal and suddenly sees through every plan and move. That captures what unfolded for Trump in that moment. A restrained courtroom action, one question, changed the power balance, pushing his side onto the defensive. The fallout reached far past this single appearance. Each misstep now exists in permanent records, available for use in other courts. The exchange proved that legal fights turn not on loud displays, but on careful accuracy, thorough readiness, and steady presence under pressure. The key lesson: in legal matters, a single precise question can undo extensive work. Trump's defense now faces closer examination, with every future step drawing heightened review. That courtroom quiet carried a clear signal to potential witnesses. Those who had delayed full cooperation now saw the defense as less secure. When an uncertain reply enters the public record, it influences decisions everywhere. Important figures, people like former aides who once held key roles, recognized that prosecutors held a stronger position. Uncertainties that had once provided cover began to fade. Choosing to work with investigators started to look like a practical choice for personal protection. Each pause or missing detail could now appear as resistance or involvement. The effect built strategically. As one witness began aligning more closely with the other side, it increased pressure on those higher up, breaking internal confidence and forcing fresh calculations of loyalty. For Trump, this went beyond courtroom events. It posed a real risk to his entire support structure in these cases. For viewers in the 45 to 65 age range and beyond, consider a stronghold once seen as unbreakable now showing clear vulnerabilities. Supporters reevaluate their commitments. Attorneys revise their plans. The opposing side advances steadily without ever needing to raise their voice. That's the current state. Quiet, exact, but deeply damaging. Prosecutors understand they don't need volume. One question, one moment of doubt, one recorded instance can alter the course, shape witness choices, and build mounting pressure that grows daily until the end. By the time Trump departed the courtroom, coverage had already taken hold. News reports emphasized the lawyer's difficulty on that one question. The silence in the room stood out as evidence of underlying strain. Online discussions spread the details, examining every aspect and replaying the hesitation from different views. For those who track these legal developments closely, this carries real weight. A major defense effort faltering under basic scrutiny raises serious questions about capability, coordination, and trustworthiness. The story quickly entered broader political discussions, talk radio, and planning within party circles. Prosecutors gain indirectly from the attention. Wider knowledge adds to the strain on witnesses, attorneys, and staff. It bolsters their position in discussions and serves as a steady reminder that every statement stays on record, open to review, and usable in various courts. Trump's team moved quickly to regain control, issuing clarifications, restating positions, and working to minimize the significance. But the exchange had already become part of the official record, public awareness, and the prosecution's approach. One question had set off effects that extended well outside the courtroom. The broader point, legal contests involve more than facts alone. They hinge on impressions, timing, and careful advantage. A single deliberately placed question, given without fanfare, can unsettle a defense, affect witness decisions, and generate coverage that multiplies the pressure dramatically. While attention focused on the case in Washington, other locations took note. Separate matters in Georgia, Florida, and New York involve their own laws, witnesses, and materials. Still, this courtroom exchange, the lawyer's struggle after one question, offers a model. Prosecutors elsewhere now see effective ways to apply similar psychological and procedural tactics. They recognize that a defense under strain tends to expose flaws or contradictions. Witnesses in those other matters feel the indirect influence. The Washington moment indicates that defense approaches can show weaknesses. For Trump, the difficulty multiplies. Facing cases on several fronts demands tight coordination, clear planning, and precise timing. A single error in one place now affects investigations into election matters in Georgia, document handling in Florida, and business issues in New York. Each separate effort gains from the visibility created by that uncertain moment. Think of it as a complex conflict across different battle lines, each independent yet linked. Progress in one area speeds results in others. The defense stays on the back foot, adjusting constantly, while prosecutors control the pace. This illustrates classic advantage in action. A lone courtroom instance does not remain contained. It spreads, shaping plans, witness actions, and timelines nationwide. The strain has built momentum that continues daily, bringing fresh challenges. Trump has faced intense situations before, but this stands apart. No shouting from the bench, no overt drama, just one direct question. Yet its impact on him ran deep. Confidence fades when a long-held plan shows cracks. He shifted to reaction mode, sharing thoughts online, issuing responses, trying to reassert direction. But each action carries the risk of becoming new material or reinforcing views of uncertainty. For his staff, attorneys, and supporters, this marked a genuine test of resolve. They witnessed the emerging flaws, the pause, and the spreading consequences from one well-timed question. Internal pressure rose sharply. Planning sessions faced disruption. Attention turned from advancing the case to managing fallout. Imagine a top executive hit with one incisive question in a critical meeting. What seemed firmly in place suddenly appears at risk, and the team hurries to regain footing. That's the scene playing out here. Trump's reaction extends beyond legal arguments. It's deeply personal. His reputation for command, hold over those around him, and public image now face direct challenge. Beyond the core charges, every response draws analysis, every comment faces breakdown, and every postponement increases the stakes. The unsteady reply quickly brought attention to gaps in the documented history. Communications, messages, and earlier statements gained new importance. Prosecutors now have clear targets for focused inquiries. Details once vague or absent, which had aided the defense, now turn against it. Unexplained lapses, withheld portions, or past claims of uncertainty become instruments for the other side. The courtroom functions as an environment of intense focus, where small elements can lead to large shifts. It's like a strategic board game where concealed moves suddenly come into view. Each absent record or unclear statement serves as leverage that can undermine long-term efforts. That hesitant response laid these issues open for everyone involved. The advantage has moved. Witnesses show greater willingness to assist. Attorneys operate defensively. Prosecutors can now link materials across cases, building a unified picture connecting Washington to other locations. The documented trail has moved from supporting role to primary force. The lawyer's moment has turned into widespread discussion. Coverage across platforms framed the defense as uncertain and disorganized. Public views form part of the larger narrative, especially among Trump's core supporters, men aged 45 to 65 and older. Party figures monitor closely campaign approaches, commitment levels, and communication adjust in response. Subtle changes appear in surveys, support from contributors softens, and assessments weigh whether legal issues affect broader viability. Media doesn't merely cover events, it intensifies the strain on those involved. Every pause, every uncertain statement, every postponed action receives close review and broadcast, creating a cycle that enhances prosecutorial strength and public oversight. This goes beyond a legal proceeding. It's where law, politics, and public opinion intersect strategically. One calm question has unleashed effects that reach well past the courthouse. The courtroom now exists in a changed environment. Records, testimony, and filings move faster. Prosecutors hold the initiative. Witnesses begin aligning more openly. Attorneys respond urgently. Trump confronts growing pressure on multiple levels: personal, legal, and political. That single question signaled a major shift. What started as a routine procedural step has grown into a complex, high-intensity legal and political contest spanning jurisdictions. Records, public attention, and witness choices now combine to form relentless momentum. Picture yourself caught in a game of enormous consequence where every action stays documented, every associate faces examination, and every brief silence gets used. That's the reality taking shape right now. The coming period will shape far more than legal results. It could alter political approaches, guide witness decisions, and influence how people see these events. One measured question set in motion a series of developments that will echo through legal proceedings, political landscapes, and beyond. Time is moving forward. The defense has to adjust effectively or face serious erosion. The country observes, understanding that this represents more than one case. It's a measure of responsibility, institutional resilience, and the strength of the rule of law.